Hey guys, it's Carolyn, and welcome back to the podcast. I'm very excited about today's guest. It's Jonelle Oldacre, who is our most senior attorney at the law firm. She's been with us for 7 years. She's also in charge of our office in California. She's licensed in Texas and California, also specialized in construction law. Good morning, Jonelle. Welcome to the podcast.
Hi, good morning. Thank you so much for having me.
So before we jump into California construction law and all that stuff, tell us a little bit about yourself and how you got to where you are now.
Yeah, sure. So I obtained my undergraduate degree from the University of Oklahoma, where I studied political science. I later graduated from Santa Clara University School of Law in 2009 and got licensed in California that year. I obtained my Texas license the following year in 2010 and pretty quickly moved to Texas shortly after that. I went to go work for a bankruptcy firm, so that was pretty fun, sarcastic. But later on, I worked for a firm that primarily practiced eminent domain law, but I did get some exposure as well to construction law. And in 2017, I had the amazing opportunity to come work for you at the Cromeens Law Firm, where, as you know, we primarily practice construction law. And now I'm board certified in the area, and construction law is definitely an area that I will practice for the rest of my career. It has a special place in my heart. But yeah, that's it in a nutshell.
So you're specialized in construction law. What does that mean?
Right. So this year I became certified in construction law by the Texas Board of Legal Specialization. So that board was established in 1974 by the Texas Supreme Court. The board certifies attorneys and paralegals that basically have a substantial experience in select areas of law. So construction law is one of those. There's also a section for criminal law, civil practice, appellate law, things of that nature. And so, in addition to continuing legal education hours, which are many that have to be completed, there's also an exam as well. So, after an attorney meets all of those qualifications and requirements, they are deemed a specialist in whatever area they tested for.
And only attorneys that have been approved by that can use the word specialize, right?
That is correct. So, for marketing purposes, once you have become board certified, you can market yourself as a specialist.
Gotcha. All right. So let's talk about California residential construction and their contracts. I know California is probably one of the most highly regulated states when it comes to residential construction. So first off, do you have to be a licensed contractor to do residential construction in California?
Yes, you do. So in California, anyone doing residential construction work that involves structural, electrical, plumbing, or mechanical work generally needs to be a licensed contractor. If you're doing work that involves things like adding square footage, installing plumbing, electrical systems, or anything that can basically affect the safety or habitability of a home, you're going to need to be licensed with the California Contractor State License Board. And that's the agency that regulates and oversees licensing in California for contractors. Now, there are some exceptions. For example, homeowners can do certain types of work in their own property without a license, like basic maintenance, repairs, and things like that. But when you're talking about major projects, you have to hire a licensed contractor. You also want to ensure that the contractor is properly insured and bonded. So basically, you have adequate avenues for recourse if the unexpected happens, like defective work, which we unfortunately see all the time.
So, and then what are some of the penalties if you work in California on these types of projects and you're not licensed?
Okay, so the biggest penalty is disgorgement, right? So in addition to, being sued by a homeowner, the California Licensing Board can also take away your profit or the money that you've earned in doing the work itself. So it's pretty serious. There's also some criminal penalties as well. So it's not something to take lightly. You want to make sure that you're licensed, and if you're not licensed, you have to be doing the work that unlicensed contractors can do. It has to be under $500, but it's better to be safe than sorry. Absolutely.
Gotcha. And so for residential construction, does California require that the contractor have a contract?
Yes. In addition to the requirement, it's also very strongly recommended to have a written contract for a residential project. In California, projects over $500, California law requires that you have one. So essentially, it protects both the homeowner and the contractor. It clearly outlines the scope of work, timeline, and payment structure, among many other things as well. So basically, without a written agreement, you're leaving yourself open to disputes, misunderstandings, and legal issues down the road. So a written contract is pretty imperative.
Yeah, well, regardless if the state requires it or not, I think it's a, the main purpose of a contract is to manage expectations and will prevent lots of disputes in the future if you can do that through a written document.
Absolutely.
So tell us kind of what is a limitation on down payments in California.
Okay, so basically, when it comes to down payments, you have to make sure that the work that's performed matches what you're requiring as far as payments, right? Um, so for residential projects, contractors are not allowed to ask for more than 10% or $1,000, whichever is less as a down payment. And when you talk about Texas projects, it seems outrageous, right? But as you said, California is very protective of its consumers. And this particular requirement is to protect homeowners from being overcharged upfront or from a situation where a contractor asks for a large sum of money without having done anything. And that's another thing that we see all the time that can be very stressful for a homeowner. So also the total payments for the project, including the down payment, should align with the work that's been completed. So contractors can't collect too much money in advance without having made any progress. Again, California is very homeowner friendly in general, but this requirement packs a punch because contractors can be required to disgorge money. So that is also one of the big penalties that contractors can face for breaking these rules and laws. You're going to lose your money. So it's very important to make sure that you are putting together progress payments in a way that is fair and makes sense.
Is that what does California require as far as mentioning progress payments in the contract?
Right. So the thing is, it's really scary. If you don't have these progress payments actually outlined clearly, you could potentially, the contract can be interpreted as saying that, okay, well, I guess payment is due when the work is complete. And as we know, contractors simply don't have the cash flow to do that. So you're going to want to make sure that you have everything outlined. I recommend that you actually model your progress payments and tie them to milestones for phases of the project. For example, when the foundation is complete or when the framing is actually done. The contract should also specify the amount of each progress payment, which can't exceed the work that has been done at that particular point. For larger projects, you can actually tie it to percentages of work. However, in general, I feel like that's a bit subjective. I particularly like to see it tied to actual milestones. That's something you can actually say, well, the foundation has been poured, so XYZ is due at this point. But again, it's crucial that you actually have it listed out in the contract. So if there's a dispute, a court can't look at it and interpret it as well. There's no, outline of when payments are supposed to be submitted. I guess you need to finish the work before payment is due. You don't want to be in that situation.
Would you recommend putting in there if you don't receive a progress payment that you have the right to stop working?
Yes, absolutely. And one of the requirements for contracts is to have mechanics lien warnings as well. So you want to break down exactly what the consequences are going to be if payment is not made. And one of them should be that you have the right to stop the work.
Gotcha. And then what must the contract contain about change orders?
So, change orders are another really important aspect of construction contracts. So, basically, a change order is a written agreement to modify the original scope of work, right? People change their minds all the time, and you need a way to document that. It's typically due to like unforeseen circumstances, but again, it could be, hey, I decided I want to expand this particular room. So, the contract must specify how change orders will be handled, how they're going to be process. For instance, it should clearly state that any change in the scope of work whether it's adding or removing items, will require a written change order. And it should be signed by both the homeowner and the contractor so that everyone's on the same page and they know what's remaining or what's being removed from the scope of work. The contract should also outline how the cost of the changes will be determined. Will it be a flat fee, an hourly rate, and how any delays that the changes may cause will be determined. Sometimes you have to alter the timeline. If there is a completion date in the contract, but now you have a change order, that has to be addressed as well. But ultimately, change orders, they prevent what they call scope creep, which, is when a project kind of starts to expand more than the homeowner anticipated, and now the cost is exceeding the original budget. But when you have these change orders in place, you know exactly how the project is moving along, why the cost is increasing, because it's all being documented.
So what happens if a contractor does extra work without a written change order?
Well, if you don't have a change order, a lot of times that work can be disputed by the homeowner. And then you have to go dig into your text messages and emails to try to prove up what the agreement was. Okay. And so you could potentially miss out on getting paid for work that you legitimately performed if there's no written change order to actually account for that work and show that it's been approved by the homeowner.
So the thing is, you got to get the extra work needs to be approved with the dollar amount and what you're doing and any additional time before you do the actual work.
Right, absolutely. Everything needs to be laid out before you actually get out there and start doing the additional work.
So so like extra work for change orders, is it the same way in California? You have to do the work and then get paid?
Well, it all really depends on the contract you have. You can't get paid for more work than you're actually performing, right? So it's very similar. It's the same process. The work has to be done before you actually get paid, and it has to be a reasonable amount that you're collecting.
Gotcha. And can you go over what the 3-day right to cancel is? I know this is in California, but it's in lots of other states as well.
It is. And we have something similar in Texas for certain situations. But yes, in California, there is a law that gives a homeowner, and actually is based on age, right? So a homeowner under the age of 65 has, the 3-day right to cancel, right? And this is a residential construction contract. But if a homeowner is over the age of 65, they have a 5-day right to cancel. And I think that's a great way to protect our elderly population, which might be more vulnerable to high pressure sales, especially in their home. This applies specifically to contracts signed in the homeowner's home. Now, if we have a homeowner who goes to a contractor's office or is in some other location and signs a contract, that's not considered as high risk for high pressure sales, right? So you don't have that same right to cancel if it's that situation. But if a homeowner comes into your home and you sign a contract, you're going to have that extra time to cancel. I myself had a windows contractor come into my home, and it was a great sales pitch. It was fantastic. They brought out all kinds of gadgets and gizmos to show me how incredible their windows were. Signed up that day. I'm glad that we had the right to cancel if we decided, wait, they kind of took advantage of us a little bit. But I think that's one of the reasons why. It's like when someone's in your home, you're more inclined to, agree to something that maybe you shouldn't.
So the 3-day right to cancel is they get to cancel with no penalty, right?
Absolutely. Absolutely. If they meet the deadline, then they can back out of the contract, no harm, no foul.
So after that 3-day right to cancel, could you write in your contract, like if you cancel after this date, I get to keep the deposit, or like some kind of penalty for cancellation outside of the 3 days?
Well, generally the rule in California is it's supposed to be very homeowner friendly, and you can't keep proceeds for work that has not been performed. So I don't recommend that.
Gotcha.
I think if you've earned that money for work that you've actually performed, absolutely. But just including blatant penalties that you get to keep funds that you haven't earned is not advisable.
Gotcha. Gotcha. Is there anything else notable that needs to be in a California residential construction contract?
Right. So the biggest thing, in addition to, the mechanic's lien warning, you also have to include your license number and information for the California State Licensing Board. Those are critical as well. And make sure that you have just the basic information. You will be surprised how many contracts forget to add a property description or something like that. A lot of contracts are, pulled from websites online, or they're just kind of put together by the contractor themselves. I don't recommend that. And the biggest thing is to have your contracts reviewed by an attorney. I think that's the safest bet for making sure that you're meeting not only all the requirements for, that are legally required, but also making sure your contract includes clauses that aren't required but might protect you down the line.
Absolutely. Absolutely. I have one other question. So, I know like the licensing board has a lot of information in California online. Do they have the language that's required to be in the contract on their website?
So the best place to go if you're looking for the language that's required is the actual statute itself. They have a breakdown of the language that is required there. So you're going to want to look to the Business and Professions Code, Section 7159. It has everything that you need there. And then if you're in doubt, of course, you can contact an attorney. You can contract the California Licensing Board, and they will help you as well. They have lots of resources, but I always recommend actually going to the statute itself.
Absolutely. And Jonelle is California licensed, so if anybody's got any questions, you can feel free to contact her, reach out to the firm. We're always here to help. Thank you so much, Jonelle, for taking the time. It was a pleasure to have you on.
It was great to be here. Thank you for having me.
Thanks.